Ms. Conlin.
May I please the court, counsel? I think the court is familiar with the facts of this case, having decided Edward, but if I may just remind you, the two women that I represent are sisters-in-law. Valerie Bandstra was and is an attorney who practiced with Brown and Winnick before she came under the influence of Patrick Edward. And her sister-in-law, Anne Bandstra, is the mother of 4 children, one of whom has special needs. Both women sought counseling from Patrick Edward, who was their pastor, and both women were sexually exploited by Patrick Edward, a crime for which he has been convicted and for which he has served time. We brought a civil lawsuit in a timely fashion, and among the things that caused us to be here is the First Amendment, an amendment of which I am particularly fond, but which was very seriously misapplied in this case. Government action does not violate the First Amendment if it has a secular purpose, if it neither inhibits or advances religion as its primary purpose, and if it does not cause excessive entanglement. And the excessive entanglement words are the words that seem to give the courts the most difficulty. The church is certainly free to reject views contrary to its religious beliefs, but it is not free to commit torts on its members. And in this case, it committed torts on Valerie and Anne. And I gave you some examples in our briefs of other kinds of torts that could be committed. If you beat somebody up, if a member is beat up for failing to confess his sins, that is the crime and the tort of assault. If the church holds a member against his will until he, to drive out the devil, that is the crime and the tort of false imprisonment. Here we have the tort of general negligence and negligent supervision. I tell you frankly, and we cited in our brief, that the cases are simply all over the place. You can find persuasive authority for any view that you wish to take, but negligent supervision simply does not implicate the First Amendment, and most of the cases, the majority of the cases, so hold. These are ordinary claims of negligence as applied.
But do you have the facts here? If the church argues that when this came to light, they fired or accepted his Edward's resignation on the spot, what evidence is there that the church was on notice before that day of any impropriety?
Your Honor, I would refer you to Gary Shaner's affidavit for some information with respect to that. They permitted this pastor to counsel women in his basement behind a locked door for many, many years. They did not have any real supervision of him at all. They met with him. They didn't ever ask him any questions except about religious matters. They didn't ever say, who are you counseling and what are you doing? I'm not sure that he would have told them, but they have some obligation, particularly given the fact that this is not an uncommon thing to have happen, to find out what their pastor is doing in his basement. And they took no steps at all to do that.
I agree with you that negligent supervision, and I think Judge Lloyd agreed with you, negligent supervision isn't barred by the First Amendment. Isn't the argument there a statute of limitations one?
Yes, and that I find that very stunning because, in fact, at least insofar as Anne is concerned, this was discovered on December 10th of 2010, and the lawsuit was brought before December 10th of 2012. And it boggles my mind that the case was dismissed. The court seemed to be very concerned about the statute of limitations and what they knew. When the plaintiffs knew that their conduct was wrong. I firmly believe that that is not, and never has been, the right question. The question is, when did these women know that they were part of Edward's search for vulnerable women who he could exploit, sexually, financially, emotionally? That's the right question. This court, in the past, back in 1990, in Callahan, took account of the status of the victims of sexual exploitation in a way that it has not done since. And I've been here often talking about the rights of women who have been sexually abused and sexually exploited. But in Callahan, you did so in a comprehensive and compelling and compassionate case. And what Judge Lloyd said was, there's nothing in the law that says you have to know that you've been injured, you have to know that you've been damaged, but you do not have to be able to take action. That is not the law. You have not overruled Callahan, and Callahan says quite directly and quite specifically, you do have to be able to take action. I wrote down page 272 just in case you want to know exactly where I found those words. You have to be able to take action. After she is able to proceed.
My understanding, though, that in that case, we were dealing with a child victim of sexual abuse as opposed to an adult that we have in this situation. Is that a fairly important distinguishing factor here?
Your Honor, in fact, these women are very like children in their ability to react to this pastor's sexual predation on them.
But
they are not, however.
But we do have special limitation for victims of child victims of sexual abuse and even accrual of rights for children otherwise that would be different from what we're talking about here, wouldn't they?
No significant difference I don't think, Your Honor, because the issue that the judge made the decision on is they do not have to be able to act. This court said they do have to be able to act. And in that case, the court held that it was the mother who had to be able to act, the adult who had to know that her child was injured and be able to act. Sexual abuse victims generally, sexual exploitation victims generally are confused. That is what a predator like Edward counts on. And she's also disabled in her ability to understand what's wrong and to take appropriate action.
Well, what about the evidence that Valerie had talked to Patty in October of 2009? Wouldn't that impute knowledge of the exploitation during that period of time?
In a sense, yes, Your Honor. Yes. In 2009, she did discover that her sister had also been exploited by Patrick Edward. And they discussed the situation and decided that they would never tell anybody because they were so frightened. Until this implicates another problem that victims of sexual exploitation by a pastor or a person in authority have. Until those people are out of the control of the authority figure, they can't take action. Whatever they know, they are unable to take action. I think that the statute is told until Patrick Edward leaves the community. That's what I think. Before they are on notice, they had to break his control over them, and that did not happen until he left his church position, until he left the community. And the issue really is, when did Anne and Valerie know that the church had blame in this situation, that the church played a causal role in their harm? The earliest possible time for them to know that would have been December of 2010. I'm not going to go into the continuing violation theory because of time limitations, but that is an alternate theory that we believe applies, and we point out to the court that never have you ever rejected the continuing violation theory. I hope that this is not the case where you choose to do that. I want to talk also about defamation per se and per quad. We say adultery is defamation per se. I was kind of stunned by Judge Lloyd's ruling that adultery it seemed to me as though he was saying it's only a moral wrong. Well, per se defamation is a moral wrong, is accusing someone of a moral wrong. You do not, in per se defamation, have to prove that the statement was published. I'm sorry, you don't have to you don't have to prove malice or falsity or damages. Those are the three things you don't have to prove. You do have to prove publication, that the statement is defamatory and that it was made about the plaintiff. So the proof is much less if it's per se. Accusing a person of committing adultery is defamation per se, according to every case you've decided since the 1900s until at least 2004.
Is there any evidence that the church actually communicated directly with people outside of the congregation, any of these statements alleged to be defamatory?
Yes, Your Honor, there's sworn statement from the elders, from people in the community. There are sworn statements that the publications came to people in the community.
I realize the word got out, but did the church do, like in the Klebenstein case, they put the word out beyond the members of the church? Did that happen here, or so anytime a member of a congregation leaks to the media or to outsiders, that's publication?
Well, Your Honor, in this case, the church took absolutely no steps to assure the confidentiality of their communications. They did nothing. They didn't even mention that these statements were supposed to be confidential. And so, no, they did not, as far as I know, they did not directly communicate with members of the media, but they did not do anything to prevent that communication from occurring. And certainly it was the talk of the town, and they should have known that what they were saying about these women would be transmitted to others. One of the defenses that the defendants assert is that they have a qualified privilege. We do not believe that they do, because you lose a qualified privilege from excessive publication. That means what I just said. I want to talk also in the 2 minutes and 12 seconds I have left about issue preclusion. Justice Mansfield wrote the opinion in the State versus Edward case and said several times that consent, which is a principal issue in this case, that consent, that free and voluntary consent is not given in a case involving the conviction of sexual exploitation. One of the things that Judge Lloyd did was not recognize that this court has abandoned mutuality of parties. He simply did not accept that. What is at issue in this case is precisely the same as the issue in the criminal case against Edward. This whole case involves his conduct and what the church did and did not do in connection with that conduct. We believe covenant cannot be permitted to present an argument or evidence regarding his conduct that contradicts the jury's finding in the criminal case. And of course, that burden of proof is beyond a reasonable doubt.
I don't want to mince words, but I think what I said in Edward, correct me if I'm wrong, is the relationships between Edward and each of the four women did not involve full and mutual consent.
That's
and
right.
I wrote it, I believe it. But the issue under the statute is consent as opposed to maybe full and mutual consent, and maybe there's a line that could be drawn there. Am I wrong?
I would never say that, Your Honor. I would say, however, that you either consent or you don't consent. And in this case, the consent was not full and mutual. These women could not consent, and as a result, they did not consent, and that is what the court, that's what the jury held in Edward's conviction. And the court, you may recall that one of the issues was whether or not whether or not Edward should be required to reimburse the crime victim's thing that pays expenses for a crime victim. And Edward cited the statute which created that crime victim's thing, and it says you cannot be caused to reimburse that money unless if in fact the conduct of the victim involves consent. And you held it didn't. You required of him that he reimburse that fund, and there was no mincing of words in that statute, Your Honor. There was no full and voluntary. It simply said consent. In the minute I have, I'm done. I'll be back.
Ms. Conlin, thank you. Mr. Thrall.
May it please the court, counsel. My name is Michael Thrall, and with Fran Haas and Mitchell Kunert, we represent the Covenant Reformed Church in Pella, Iowa. This case presents important issues of the freedom of religion under the First Amendment of the United States and Article 1, Section 3 of the Iowa Constitution. The plaintiffs essentially asked this court to pass judgment on questions of sin, forgiveness, temptation, and repentance. At times, the plaintiffs have attempted to argue, and have argued both here and in the lower court, that the church is attempting to hide behind the First Amendment. And I respectfully submit in making that argument, it's not only simply wrong, but trivializes or minimizes one of the most important constitutional rights that we hold as citizens of the United States and as citizens of the state of Iowa.
But, Mr. Thrall, don't we also have a criminal act going on here?
We have a criminal act, but I think it's important that while the plaintiffs originally sued and brought a civil claim against Mr. Edward, they dismissed that claim with prejudice, and at the same time dismissed the respondeat superior claims, or the vicarious claims that they were making predicated directly on his conduct against the church. So we've removed Mr. Edward's conduct from this particular case as it relates to those claims,
Except
and
you have the
instead are dealing just with the claims against the church.
but you still have the negligent supervision claim. And as I understand it, the notion is, well, Edward, however you pronounce it, was obviously an employee of the church, pastor of the church. He was put in a position where he might engage in improper conduct. The church didn't properly supervise him according to this. I mean, I'm just, as you know, presenting what I understand is a plaintiff's claim. My first question is, certainly that's a viable cause of action from a legal point of view. It's a question of facts, I understand, but the church could, in theory, be liable, in legal theory, be liable for negligent supervision of its pastor. Don't you agree?
Well, Your Honor, I guess there are 2 points. One, the court need never reach that issue because of the statute of limitations argument, and I'll come back and address those. But certainly it is our argument that in the context of this case, that for the court to pass judgment on the court's supervision of Edward would cause it to become excessively entangled with religion, with the church.
I mean, let me just take you on a little bit there, and please push back, but the church has a pastor. The pastor's in a confidential relationship with parishioners. Certainly, whatever the religion is beside the point. When an employer has an employee that has the opportunity, at least, to engage in sexual exploitation, certainly the employer has an obligation to reasonably supervise in some fashion. You know, I mean, I'm not sure what that means, but that certainly is a secular notion, is it not?
I agree with you, certainly, but I think certainly you have to interplay then with the First Amendment And for example, in this case, the church board of elders was meeting with Edward twice a month. They met monthly. Does the court then become involved in dictating to the church on how many occasions it is to meet with Edward? There are complaints about where Patrick Edward would counsel or meet with people. Does the court become involved in?
It's the same problem you have in a private employer who's not religious. I mean, that's a factual issue as to whether or not there was proper supervision, not whether there should be supervision.
I agree, but I guess the interplay that I believe comes into play is that because it's a church and because the First Amendment protects the free exercise of religion and protects against the establishment of a religion, that those protections need to be interplayed in terms of the role a court can play in getting itself involved in how the church fulfills different roles.
Is there a church doctrine that says the elders do not have to supervise their employees?
No.
So it's not a religious thing.
No, it's just in terms, the argument that we are making, Your Honors, and again, this is secondary to the statute of limitations, which I think carries this particular claim and results in its dismissal, is that to become involved in that process entangles the court in making decisions and judging how the church would fulfill how it supervises the pastor. But I think, as I indicated, I think the key question on that issue,
But I mean, and I agree maybe the key question is the statute of limitations, but I mean, didn't the legislature cross that bridge already? If you're going to criminalize, make a statute prohibiting sexual relations with someone you're counseling, then including religious officials who perform counseling, which we said was constitutional in Edouard, then doesn't that put on the employer of Edouard a duty to supervise that person to make sure they're not engaging in that criminal conduct?
The criminal statutes, though, are particular to the pastor, to the clergyman, person that is counseling or performing that role. The state legislature has not criminalized conduct of the church in allegedly failing to supervise the pastor.
Well, let's get into the statute of limitations, because I know you're anxious to, and I'd like to hear. I mean, my understanding is that the plaintiff suggests, well, we had certain knowledge along the timeline, and that knowledge may well have been outside the statute of limitations, but we were frozen from acting, I think. I'm putting words in her mouth, but that's what I'm hearing, that we couldn't act because we were under the influence of the pastor. Anyway, that's my rough rendition, but I'd like to hear your response on the statute.
Yes, and I think certainly under the undisputed facts of this case, both claims are barred by the 2-year statute of limitations in section 614.1. And I think Ms. Conlin frames the wrong dates for the court. She talks about December 10, 2010 as to when the conduct was discovered. December 10, 2010 is when Ann's husband, Ryan, came home and discovered Ann and began to learn of the conduct. The church doesn't learn until December 13, 2010, but the important question is when the women knew and when the women should have known and had imputed knowledge of the elements of their cause of action. And I submit that that occurred much earlier. She contends that in her first interaction with Patrick Edward that occurred in his study at his home while his wife and 4 children were home, that she was raped. And she indicated in her sworn testimony that she knew that night that she had been raped, and she also testified that she began experiencing mental distress that night. In October of 2009, when she talked with her sister, Patty, she testified that she knew in her gut what he was doing, and that he was using his position to recruit women for the very purpose of abusing them. She knew it was more than a wrong, that it was a pattern. She was worried about what he might be doing with other women, and indeed accused Patrick Edward at that time of clergy sexual abuse in so many words. and broke off communications. All of that occurred, and I think under this court's case law, clearly establishes all the elements for the statute of limitations defense as of that time. But that still is not all of the evidence that you have in front of you, because in April of 2010, Valerie Bandstra undertook treatment and went to see a counselor that she attributed her self-destructive behavior to Edward's abuse, and the counselor confirmed that her treatment of Valerie was for this sexual exploitation by Edward.
Let me ask you this. The question, I think, or at least part of the question is, what do you need to know? And there's no doubt, I take it, it's virtually undisputed that the plaintiffs knew at the date of these sexual encounters, they knew that happened on whatever date the record shows. The claim here, though, is one of negligent supervision. And so the question is, well, when did they know or reasonably should have known that the church was engaged in negligent supervision of Eduardo? I want to give you an opportunity to challenge what I've said so far.
Well, I think certainly, and I find this argument interesting because they're challenging the church. They're suing the church, arguing that the church failed to supervise Patrick Edward, and as a result, he had sexual relations with him. He exploited them. They knew at the very instant that they realized they were being exploited, or they were realizing they were having the sexual relations, that the church was not supervising them.
Is that true? I mean,
well, how could they? I mean, what else could there be? I mean, they're asking us to. They're essentially saying that the church failed to supervise Patrick Edward and allowed this to happen. And so when they know that this happened, when they realize, for example, in the case of Valerie, that this was clergy sexual abuse, they know at that time the church has not supervised, or at a minimum, they've been placed on notice, inquiry notice, with a duty to reasonably investigate that particular claim. So I think from the minute in the context of a negligent supervision, if the claim is you failed to supervise that pastor so that he now has sexually exploited me, they know at the time of the sexual exploitation that at least they're on inquiry notice that the church has failed to supervise that particular pastor. Nobody else knew. I think the record is undisputed that until December 10, 2010, nobody other than the women had any idea. There were tens, 20, can't even count how many people were deposed in this case, all of whom were asked if they had any inkling, any indication, any red flags, and they all testified not. So I think certainly within the context of the statute of limitations, they were on inquiry notice at a minimum and certainly knew enough to have brought the claim. Anne, I think, had indicated that she knew from May of 2008 that it was wrong, inappropriate. In May of 2010, she had testified that when she learned that Patrick Edward was having sexual relations with Valerie, Sandy, and Patty, all of whom she understood he was counseling, that she put the pieces together very quickly, broke off contact with Patrick Edward, and indeed Valerie broke off contact and communication with Patrick Edward in 2009.
Why wouldn't this be a factual question where the jury has to decide the plaintiff's knowledge versus the sway or whatever Eduardo, is that his name? I don't know how to pronounce it either, had over, or the pastor had over these women?
Well, two points. Number one, I think the facts that I've recounted are undisputed, and I think those undisputed facts in and of themselves establish that defense. Secondly,
but isn't it undisputed he was continuing a relationship and held some power over these young ladies?
Well, I think that would be disputed, but I think the women themselves, and Valerie has indicated that she understood all of those facts at the time. And this court has looked at, in the context of other cases, Callahan aside, which I do think is distinguishable because of the minor situation and the repression syndrome. But if you look at the other cases the court has held in the context of PTSD, knowing but being scared to come forward, that has not serve to excuse a person's failure to come forward and file their lawsuit in a timely fashion. I do want to briefly, in the time I have remaining, talk about the other claims which I've characterized generally as the negligent Christianity. In other words, the general negligence claims the plaintiffs have brought in terms of how they believe the church should have ministered to them after these events were discovered, and also the defamation claims. And I think certainly in the context of those claims, the First Amendment clearly bars the claims that they've asserted. I think Ms. Conlin ignores the fact that there is absolutely no dispute that the women had sexual relations with Patrick Edward. And then the argument becomes, how does the church view that? How should the Bible view that conduct? Is it sin? Is it something that the parties need to reconcile with God by coming forth and acknowledging that sin and seeking forgiveness? Or, as the women contend, are they completely without blame and no need to sin or no need to seek forgiveness? And those issues can't be resolved outside the context of the doctrines of the church, what they believe, what the elders believe, and I think all of those things implicate First Amendment issues that the court historically has avoided and indeed views its role as making sure that it does not get involved in resolving those issues.
I want to go back for a second. I'm sorry, just before the time expires. Too late. I'm going to go ahead. Can I ask a question, Chief? With regard to the limitation provisions and the negligent supervision, when you have a situation where, and this is where I want your response, when you have a number of women who are in this situation, they obviously don't apparently have the ability or feel the need or are able to express themselves to the elders of the church. And this is where it gets into the maybe the ongoing claim that they didn't feel like they had anywhere to go and complain, because as I think the record reflects that they have, the elders are all, enamored with this minister. They're in charge of the minister. They don't have anywhere to go until they finally, as of December of 10th or the 13th, whenever it finally comes to the attention that they can't do anything anymore. Why isn't that the appropriate time when the limitation or the action really accrues or starts?
Well, first of all, I would challenge your premise. I think they could have gone to the elders. They could have gone and should have gone to the church. And I, in support of that, I go no further than to remind the court how quickly the elders moved when they first learned of these events. And keep in mind, what they first learned of was a kiss that was reported. They had literally within hours met with Edward. They had accepted his resignation. They began the process to depose him to ensure that he would never serve as a minister again as this process unfolded. So I would argue with you and dispute your underlying premise. But I think certainly in the other cases the court has looked at this question, absent the repression syndrome, repressed memory, that is not served to excuse a party failing to bring a timely cause of action. And particularly if you look at Valerie, for example, she did reach out. She had counseling well outside the 2-year statute of limitations. So I think both factually, legally, they were on a duty at that point in time to have brought the case and to have brought it much earlier than the day that everybody else found out about it. We would respectfully request the court affirm the rulings of the Iowa District Court, and I thank you for your time today.
Mr. Thrall, thank you as well. Ms. Conlin.
It is easy for Mr. Thrall and the elders to suggest what these women might have done or should have done or could have done. The fact is they could not and should not be held to a standard that almost all women in this situation cannot meet. We have a statute of limitations. That statute of limitations, however, must be applied to the same population as these women were a part of it. Can't be applied to the general population. It absolutely must be applied in the same way it would be applied to other women who were under the influence, criminal influence, of a psychotherapist, or in this case, a clergy person. I would rely heavily on the affidavit attached in the appendix of Gary Shaner, who has done 3,000 of these cases and certainly knows how women react. I would have relied on him to explain to the jury how unlikely it is for a victim to report her pastor and all of the psychological barriers that prevent that from happening, and they're very serious. Mr. Thrall suggested to you that there were no red flags, that the elders were perfectly innocent of information, but that is not the record. Mr. Ryan Bandstra testified that Mr. Hedinger, who was the head of the elders at the time, said after the report that there were red flags and that they were going to take them up. Please do not overlook that. And this lawsuit is against the church for its conduct in connection with what Edward did. I ask that you return to Callanan, that you compare these women to the mother in Callanan. That's who you held the statute applied to, and that you look at what you said about what happens to people in these situations. I didn't get a chance to talk about the continuing violation theory, which was in fact applied in 1907. None of us were around at that time. But Brainer was a sexual molestation case, and the district court brushed it off as an evidentiary matter, but it did say that this was a continuing violation.
And this may be a difficult question, but I mean, is it possible to distinguish your two clients as far as the statute of limitations? Because if we apply the continuing violation theory and the other arguments you've raised, one of them was clearly under his influence until within the statute of limitations.
Yes.
The other one had broken off relations with him, had sought out and obtained counseling independent of the church more than 2 years before bringing suit. Isn't that a significant difference?
Your Honor, the court can do whatever it believes to be right and just, and if there are distinctions between my two clients, but keep in mind, Valerie Bandstra was going every Sunday to that church. She was hearing him preach. She was watching the conduct of the other members of the church and of the elders with respect to him. He was so highly regarded that any attempt that she made to report this to anybody would have been rebuffed. She would not have been believed, and that is the truth. And we see example after example after example of women coming forward today whose assault took place decades ago and who did not come forward because they would not have been believed, and they knew that. And that is the situation that Valerie Bandstra found herself in throughout this until Anne was discovered. With respect to excessive publication, this is Pella, Iowa. It's a small town. It's a big scandal, and the fact that they did not take any steps whatsoever to protect their communications does make them potentially exempt from the qualified privilege. I wanted to say a word about Ruth Meyer in 1917 and those elders who were held to be ministers. There's all kinds of distinctions between Ruth Meyer elders, Presbyterian elders, and elders in Covenant Church, and it is to the doctrine of the church that the court looks to determine whether or not any clergy privilege should be applied. And in this case, the court applied the clergy privilege to everything, minutes, conversations between themselves, conversations between them and other people. I do respectfully request that the court reverse the lower court and let a jury decide whether or not these two women and their husbands deserve compensation for the egregious wrongs committed to them by the church of which they were members in good standing.
Ms. Conlin, thank you. The case of Bandstra versus Covenant Reformed Church is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.